Can't swim. Like anyone from New York or New Jersey would never step foot out. not relevant to this particular case. There were other firearms that we didn't introduce. So I've instructed our witness from the lab not to discuss those items. So I just wanted everyone to be aware that I have instructed him not to.
Thank you.
Okay, and I'm assuming there's no objection to that.
Sounds good from our perspective.
Have we addressed the issue on stipulation of identity of the deceased?
I don't believe we have. I know Mr. Shield emailed the stipulation order.
We're not stipulating on behalf of the children.
Okay.
They're not stipulating, so that will be something to be. All right, we'll go back off the record until
And did he indicate to you, whether or not he was originally driving?
He said he was picked up, and the male in the back seat was driving originally and asked him to drive.
And did he say where he was picked up from?
Dillard.
After speaking with the drivers on scene, did you have any further involvement in this case with the traffic portion of it?
I just completed the traffic crash report and then cited him with a ticket for failing to yield.
I have no further questions.
Cross?
All right. Good morning.
Morning.
So you get to this scene, did you talk to anyone else about having witnessed the accident? Any other witnesses making any reports about it?
There was no witnesses that approached me or that we found on scene.
Okay. So is it fair to say that if Mr. Newsom hadn't appeared at the scene, give you his ID, probably would never have known who was driving that car?
We had the owner of the car's information, and then we contact the owner to see who they gave the car to.
Okay, so you knew the owner wasn't driving?
Correct.
Right, but the owner could have given you information as to who they had leased or rented the car to, correct?
Correct.
Did you follow up on that or not?
An officer that had responded to the scene called Miramar and asked the owner of the car. And they said the vehicle was not stolen.
Okay, and did you confirm that Mr. Newsom had nothing to do with renting that vehicle?
No, I did not do an investigation on that.
Okay. So you faulted the Dodge Journey for pulling out into traffic without yielding?
Yielding the right of way to making a left turn to oncoming traffic.
And the individual that you described as Trayvon Newsom actually gave you his driver's license, so you know exactly who he was, is that correct?
Correct.
Right. And he indicated he hadn't originally been the driver of that car, but someone at some point had asked him to take over driving.
Correct.
Nothing further, thank you.
No questions, sir? No problem, sir.
No reason.
Thank you, ma'am. You are excused. Please do not discuss your testimony with any other witness.
Thank you.
Next.
Judge, he's on his way up from the first floor. He'll be here in about 2 minutes. It's going to be Marshall Wolcott.
Okay. Let me know when he's here.
Okay.
Judge, may I first? If we need to. Raise your right hand and be resworn.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please state your full name, spell your first and last name for the record.
It's Detective Marshall Wolcott, Marshall. Last name is spelled Wolcott.
Thank you. Good morning, Detective Wolcott.
Good morning.
Again. Just remind us again, please, where you work.
I work for the Broward County Sheriff's Office. I'm currently with the crime scene unit.
Okay. And I know that you previously gave us your training and experience. With respect to this investigation, I'm going to show you what's been marked for identification as states triple P. May I approach, Your Honor?
You may.
States triple P, do you recognize it?
Yes.
And how do you recognize it?
These are the two projectiles that were collected during the autopsy.
Okay, and are the autopsy number that is generated by the Broward Medical Examiner on the package?
Yes.
How about the Broward County Sheriff's Office case number that was generated in this case?
Yes.
And is the packaging collection and the way that this evidence was kept subject to the BSO protocol that you previously testified to in this case?
Yes.
And does it fairly and accurately, or does it appear to be in the same or substantially similar condition as when it was collected in 2018?
Yes.
At this time, I move into evidence states triple P as
67.
67, state 67.
No objection. No objection. No objection.
Without objection, what was previously marked states triple E for identification shall be received in evidence as states 67. You may publish at will.
Thank you, Your Honor. I'm going to show you what's been marked for identification as states triple Q.
You may.
Do you recognize states triple Q?
Yes.
How do you recognize it?
They were the prints that were taken during autopsy.
Okay. And does it have the medical examiner's number from the Broward Medical Examiner's Office?
Objection to hearsay.
Yes, it has. It does.
Okay. And how about as far as the date that they were collected?
Yes.
Objection to hearsay.
And is the card that was collected from the medical examiner's office appear to be in the same or substantially similar condition as when it was collected in 2018 from autopsy?
Yes.
At this time, I move into evidence what's been marked as triple Q as 68 as the next numbered exhibit.
Motion to go out of witness.
You may.
You did not roll these prints, correct?
I did not roll those prints.
You were not present when the prints were rolled, correct?
No.
So everything you're relying on is just what's written on the card, correct?
Correct. I have seen that before. I was aware of it when we were packaging all of our evidence, and myself and Detective Williams when we were doing everything. I have seen this before. I've dealt with it before.
Right, but you didn't see them actually roll.
No, I didn't see them roll it out at the autopsy at the medical examiner's office.
Nothing further.
At this time, I move in what's been marked for identification as states triple Q as state 68.
You object to lack of foundation and lack of authentication.
Join on behalf of Mr. Williams.
Join on authentication.
As far as it being a card that was collected by the sheriff's office, it's been authenticated to that degree. before someone can testify as to what it is or what it portrays or the significance of that, more foundation needs to be laid. But your objections overruled at this point as to the noticeability of the card as being something in custody of the card share.
Okay, thank you.
So over objection, what was previously marked triple Q will be receiving evidence as state 68.
And Detective Wolcott, I'm showing you state 67. That's been entered into evidence. I'm not gonna open the package as it is biohazard material. If you could please tell us what is state 67?
They are 2 projectiles.
And the projectiles were recovered from the victim in this case at autopsy?
Correct. So generally, anytime an autopsy is done and there are projectiles that are still inside the victim, they will remove them from the victim and then they will transfer them into our custody for our investigation.
Okay. Were these 2 projectiles submitted to the Broward County Sheriff's Lab for further analysis?
Yes.
No further questions?
Ross?
No questions, sir.
No question, Your Honor. On behalf of Mr. Bovary.
Thank you. You are excused. Subject to recall, please do not discuss your testimony with any other witness. State, call your next.
State calls William Ruiz Fontanez.
Raise your right hand and be sworn.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, may you see it.
Thank you.
Please state your full name, spelling your first and last name for the record.
First name William, W-I-L-L-I-A-M. I have 2 last names. First last name Ruiz, R-U-I-Z. Second last name Fontanez, F-O-N-T-A-N-E-Z.
You may inquire.
Thank you, Your Honor. Good afternoon, or good morning.
Good morning.
Yes. How are you?
I'm doing well, and you?
Good, thank you. Can you please introduce yourself to the jury and let them know who you work for?
Okay, my name is William Ruiz, and I work for Broward Sheriff Office Crime Lab as a firearms examiner, criminalist 3.
What does that mean?
Okay, so I work for the crime lab of BSO, and what I do is analyze firearms and firearms related items that are submitted by different agencies here in Broward County. Then I testify in court when summoned and produce a report of my findings.
All right. How long have you worked for BSO, the Broward Sheriff's Office, in that capacity?
I just turned 8 years working for BSO.
Congratulations.
Thank you.
Prior to working for the Broward Sheriff's Office, have you worked anywhere else in that same capacity?
Yes, I did. I used to work for the Puerto Rico Institute of Forensic Science, where I worked for a total of 6 years.
Okay, and what types of things did you do while working there?
As well, I worked for the firearms unit. I was a technician for 2 years. After those 2 years, I was promoted to become a firearms examiner in training. I completed a 2 years training that was focused on different modules pertaining to firearms, such as firearms history, the history of gunpowder, how firearms work, visiting manufacturers of firearms and manufacturers of ammunition, also attending armor courses, and also attending firearms manufacturers in order to see how firearms are made and how the parts leaves their markings on the firing pin, on the firing cartridge case, and the fire bullets.
All right, now, prior to having that job, can you tell us a little bit about your education in order to then move to what you do now?
Yes. I have a bachelor's degree in forensic science and a master's degree in criminal justice, both from the Inter-American University of Puerto Rico.
Now, you discussed briefly just now your training in order to do what you do. You said you visit manufacturers. So what's the purpose of doing that? What do you see when you go there?
It's in order to understand how firearm parts are made and how, when they are made, they leave their markings on the fire cartridge cases and bullets, and how they come together, what manufacturing process do they use, that those are going to leave tool marks in fire cartridge cases and projectiles.
Okay, now you also indicated with your training, I think you said it was a 2-year training in firearms and tool marks, and there was 2 modules to it. What were those modules?
Oh, there were more than 2 modules, actually, there were 12 modules. It was in firearm history, history of gunpowder, make and manufacture of firearms, make and manufacture of ammunition, serial number restoration, analysis of firearm, courtroom testimony, as long as many others.
Okay, and are you certified in firearms and tool marks examinations and comparisons?
Yes, I am. The Association of Firearms and Tool Mark Examiners, I am a certified member for 5 years now. And what you need to do is you have to take a test in firearms identification, and that's a written test. After that,
Monster.com makes GANs great again. Yeah, you know what? I'm not going to say again because they never were, and they're complicated. See, with Monster.com, making a Gantt chart is as simple as throwing a process of project stages here, adding owners and timelines and whatever other details you need here, and then, boom, you got GAN. And it has all the features you've always wanted. Way much better. Like, for example, if there's a delay at this stage, I can just update it. But not everyone you work with wants to use a GAN. And with Monster.com, they don't have to, because they can view and manage the same workflows and data, but in the way they want. Now your work is really centralized, so you can achieve more in less time with less hassle. Now that's progress, because Monday.com makes GANs great. Make one yourself in minutes. It's free to try. You don't even need a credit card.
This week on Wheel, it's all about the teens.
I have a lot in common with teens. The suit, for example, is 13 years old.
I like money!
I asked for your favorite subject, and you said?
It's lunch.
Okay.
Gotta eat.
Weeknights at 6:30 on CBS 58.
Your Honor, at this time, the state tenders witness.
Did anyone wish to what here? All right, let me instruct. Members of the jury, the witness is being tendered to you as an expert by the state in the field of firearms and tool mark identification. Expert witnesses are like any other witness with one exception. The law will permit an expert witness to give an opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Whether or not a witness is an expert is a decision for you to make. The court is not allowed to take a position on that matter. Like any other witness, you may properly believe or disbelieve all or any part of a expert witness's testimony. You may proceed.
Thank you, Your Honor. All right, so Mr. Luis Fontanez, can you explain to the ladies and gentlemen of the jury what a tool is? Because we hear the term tool marks, so what's a tool?
it comes from the premises that when two objects come into contact, the harder of the object will leave its impression on the softer object. So therefore, the harder of the object will be considered a tool, and it's going to leave a mark in the softer object where a tool mark is left. And for example, let's say you have a hammer, and then you have a piece of wood. The heart of the object will be the hammer, and the wood is going to be where the impression of that hammer is going to be left when they come into contact.
So in this particular case, would a gun be the tool?
Yes, in this particular case, you have a gun that it's a harder metal than the metal used to create ammunitions. Therefore, the impressions of the firing pin are going to be left on the fire cartridge cases, and the impressions of the barrel are going to be left on the fire bullet.
Now, I know that you brought a demonstrative aid with you to discuss casings and ammunition. Your Honor, may I have permission for the witness to step down and utilize his demonstrative aid in front of the jury?
You may.
Thank you.
And you can come step here so that all the jurors can see, because I know there's a large group. Just keep your voice up so that our lovely court reporter can hear you, okay? All right, so what are we looking at here?
Here we have an example of what is known as a cartridge. Definitely, it's a big cartridge. It's not like this. They come in different calibers. And a cartridge, a light cartridge, has 4 components. You have a bullet, you have a cartridge case, you have the primer, and then you have gunpowder inside. And this is what is loaded into a firearm. How it works, a light cartridge goes inside the chamber of a firearm, and then when the trigger is pulled, the firing pin, it's going to strike the primer of the cartridge. That's going to create a spark that is going to ignite the gunpowder inside the cartridge, and that powder is going to turn from solid to gas, so it needs to come out. And how it happens is that it's going to propel the projectile. This is an example of a barrel, and you're going to see that inside the barrel, you're going to have lance and groove impressions. The lance are going to be the raised portion, and the groove are going to be the concave area. And you see that it also has a twist, and that's for, you can use for reference when a football player is throwing a football, it actually gives it a spin. So the same thing is going to happen to the bullet when it's traveling down the barrel. All the impressions from that land are going to be then left on the projectile. And this is known as striations. And those striations are unique to each barrel. And that's how a comparison can be produced. So you have tool, the firearm, and the tool marks being left in 2 places. In the fire bullet, and also in the fire cartridge case around the firing pin. Also the ejector marks, the extractor marks, when the casing is ejected from the firearm. When I do a comparison also, what I'm doing is, if a firearm is submitted, I'll test fire the firearm and compare it to the fire bullets found on the crime scene. And I use a microscope that has 2 bases, a comparison microscope. And I can compare 2 objects at the same time and try to find where the striations are aligning with each other. And that's what is called an ID. So you have to search, let's say a bullet has 5 line impressions, you have to go to each line impression in order to see if they're aligning with the other one. So it's a process, but it's what we do as firearms examiner.
All right, thank you. You can have a seat, and we're going to break down everything you just told us a little bit more.
Thank
you. So you told us that the impressions left are individual and unique to each particular gun, correct?
Yes.
So would that be similar to like a fingerprint or a DNA to someone?
Yes.
Can any 2 guns have the same striation marks, lands, grooves, impressions?
No.
So if we have lands, grooves, impressions, striation marks on a particular bullet or casing, can they only match to a particular firearm that shot it, no matter what?
Yes.
All right. So walk us through the general process of when you receive evidence, how you go about doing your examination.
Okay, the evidence is submitted in containers, and they also submit it with 2 documents. The first document is going to be a property receipt, where the description of the items that are being submitted are in that document. Also, a CO15 that stands for Crime Lab Form Number 15 that describes what type of work or analysis they're requesting from the crime lab. So the first thing I do is I receive the container. Well, I actually go and look for the container because in the firearms unit, we have our own vault. All the firearms and firearms related evidence, it's inside our vault. Therefore, I take the evidence out from our vault and I verify, open the container and verify that the items that were submitted in the container matches what is described in the property receipt. After I do that, then I proceed to log every information into a system called Starlens, where all the evidence is documented and all the analysis that are going to be performed with each item is documented as well.
All right. So can you tell us the difference, I guess, between class characteristics and individual characteristics that you're looking for when doing an examination?
Yes. For that, am I able to use it? Yeah.
Yes, whatever demonstrative aid will assist you in explaining that to the jury, please.
So in case of a barrel, let's say, for example, company X wants to make the barrel that has 5 lands and 5 groove in their barrel. That means the company X said, all my guns are going to have 5 lands and 5 groove impressions. That is considered a class characteristics. Why? Because it was established by the manufacturer. Why they don't intend any accidental markings that are going to be left in that barrel when the barrel is being produced. For example, when the drilling is done in the barrel for the first time, it's a cylinder made out of steel. A gun drill, it's going through that steel and then producing a hole in the center. Then that hole has another process that is called reaming. When that reaming process is actually done in the barrel, it's leaving accidental markings that are going to be individual for each barrel, for each land, for each area in that barrel. So therefore, those were not intended by the manufacturer. Therefore, those are individuals to each barrel. In case of the cartridge case, I was talking to you about the firing pin. The firing pin, the same, it's a piece of metal that is going to be made, and they can say, well, that piece of metal is going to be round tip. So you're going to see a hemispherical firing pin impression. That could be a class characteristic, but inside that firing pin, they can be deformations, they can be things that happen during the manufacturing process that is going to be leaving individual markings in that firing pin impression. Also, there's a part of the firearm called a breech face. That breech face, when it's being manufactured, it also has unintended areas that are going to be leaving individual characteristics because they were not intended by the manufacturer. Therefore, that breech face is going to be also individual for each firearm. And as a firearms examiner, we look for individual, we look first for class characteristics in order to see, well, the firearm has a round tip firing pin. This fire cartridge also has a hemispherical firing pin shape. But okay, now let's go to the individual characteristics, those that were not intended by the manufacturer. Those are the markings that are going to separate and individualize the firearm from other firearms produced with the same class characteristics.
All right, so you told us, you mentioned the term, I think it was firing pin is what you said. So firing pin I know is with inside the gun, but is that what moves when you pull the trigger?
Yes, when you pull the trigger, the firing pin is going to strike the primer area of a cartridge case.
And then what is the term for the item that is expelled out of the actual gun?
That will be a fire cartridge case.
Okay, and that's what pops out of the side after the bullet goes out, correct?
Yes,
Okay. And so do both the bullet itself and then the fired casings have individual markings that you can compare?
yes.
All right. When we say live cartridge, what does that mean?
It has the 4 components, which are a cartridge, primer, the bullet, and gunpowder.
So does that mean it's not fired yet?
It hasn't been fired.
Now, explain to us the term cycling marks. What does that mean?
Once a cartridge is loaded into the chamber of a firearm, there are many processes that you have to take. For example, if it's a pistol, you have to load the cartridge into a magazine. The magazines is where the cartridges are loaded in order to then introduce that magazine into the magazine well. Then you pull the slide back, and what are happening during all those processes that the cartridge, it's getting markings from the magazine. It's also getting markings from the extractor and the ejector that are parts that hold that cartridge and put it into place. And also whenever the firearm is fired or not fired, just simply that the slide was pulled back. The extractor and ejector eject that cartridge because it wasn't fired. It's a live cartridge then. And those markings are also left on a live cartridge.
You said the term magazine, and I'm sure many of us know what that is, but I just want to have it explained. Is the magazine the portion where you actually load the ammunition and then put it into the gun?
Yes,
You indicated something about markings from the magazine. Is that called a lip marking?
magazine lip marks.
Now, are those also individual to each particular magazine?
They can be.
All right. So what does it mean to actually cycle a round through a firearm?
Okay, so it means that the cartridge was loaded into the firearm, but it wasn't fired. Then an action was used, for example, the slide pulled back and the cartridge was ejected from the chamber.
Now, you said the term slide, so I'm going to have you explain what the slide is as well on a firearm.
Okay, the slide is the area of the firearm that puts the chamber or puts the action in battery. Another term for in battery, that the firearm is ready to be fired. So the slide is the part that closes the action in order for the firearm to be safely fired.
Okay. Now, can someone cycle a live cartridge through a firearm without it actually expelling the bullet?
Yes.
Okay, and can you explain to us how that can actually happen?
Okay, for example, if we have a pistol has a slide. I would first load cartridges to the magazine. The magazine then I would introduce into the bottom part of the pistol, and that's called a magazine well. Then I would pull back the slide, and when I'm pulling back the slide, as I release that slide, a cartridge from the magazine is being stripped and put into the chamber of the firearm. And then I have two options. Either I press the trigger and the firearm will fire, or I simply pull back the slide and the live cartridge will be ejected from the chamber of the firearm. Therefore, we will have cycling marks left on that cartridge, but the cartridge wasn't fired.
So let's talk about now the case we're here for today. Were you assigned to review any firearms or tool marks evidence for lab number 18-07119?
Yes, I did.
Okay. And can you tell the ladies and gentlemen of the jury on that specific lab number on June 26th of 2018, what evidence you reviewed relevant to this case?
Okay, a total of 4 fire bullets were submitted, and 2 fire cartridge case and 1 live cartridge.
So when you received the evidence, Is it in the typical brown paper bags that we see, our crime scene units put the evidence in when they deliver it to the lab?
Yes, when it's cartridge and casings, cartridge, they can be either in a brown paper bag, in a sealed vanilla envelope, or they can be in a container. It's a brown, a white box. It's called a gun box.
So I want to talk about the first thing that you received on your lab report. I'm showing you what was labeled as JO11. Do you recall receiving that as part of the evidence that you reviewed in this case? Or item number, I guess it would be 2 on your lab report. Do you recall receiving that?
Yes,
And when the lab receives evidence to review, is that the green sticker that is placed on it?
it varies per year. So the particular year, 2018, was green.
Okay. And do you recognize this particular item?
Yes, I do. I see the case number. If you see the white label that says Exhibit 2, JO1, has the case number 1807119, and it also has my initials, which are WJR.
And do you recall what this item was?
That it's a spent bullet.
And when we say spent bullet, what does that mean?
It means that it has been fired, and you're gonna have land and groove impressions on the surface of the bullet.
Now, you also received labeled as Exhibit 3 and 4, or CRW1 and CRW2. Do you recall receiving that evidence as well for comparison?
Yes, I do.
Okay. And what were those items?
Those are two 22 long rifle, manufactured by Aguila, fire cartridge cases.
Okay, and do you recognize, it states 30, I'm showing you.
Yes, I do.
Okay, and how do you recognize it?
I see the two labels on the left-hand side, bearing Exhibit 3 and Exhibit 4, and also bearing the lab number 18-7119. And both stickers, labels, have my initials, WJR.
And I believe these were the fired casings on scene, correct?
Yes, they are.
Now, you also received some evidence from the medical examiner's office, correct?
Yes, I did.
And was that labeled as, for your purposes, 5 and 6?
Yes,
Or MEO3 and MEO4?
yes,
Okay, showing you states 67. Do you recognize this?
yes, I do. I see the lab number 18-7119. Also, I see two labels reading Exhibit 6, ME04, and my initials, WJR, and Exhibit 5.
And what are these that we're looking at here?
Those are going to be two fire bullets.
And are these the fired bullets or the projectiles that were found within the victim's body from the medical examiner's office?
Yes, they are.
Did you also receive a 22 LR caliber live cartridge labeled Exhibit 7 or SW1?
Yes, I did.
showing you states 29. Do you recognize this?
Yes, I do. I see the lab number 18-7119, also the label bearing the number 7, SW1, and my initials WJR.
And what is that we're looking at?
That is a light cartridge. That light cartridge in particular had a light firing pin strike on it.
We'll get to that in a second. So you receive all this evidence, it's in the packaging, you take it out all at once, or walk us through your process.
Oh, I start one by one. I open the container, make sure that inside in the container has what is actually being described. And if it has any correction, I will correct it. For example, it says fire bullet and it's a fire jacket. I would change that in my notes. I know the weight of the bullet. I also know the diameter, and the diameter is going to be the distance of the base of the fire bullet. So you measure it from land impression to land impression, and that is the diameter of the bullet. And I also document the state that the bullet is, and also prior to all that, disinfect the bullets using a 10% bleach solution.
Now, with the evidence that we just went over, did you in fact do a comparison of all these items?
Yes, I did.
All right, let's start with Exhibit 2, which is the States 37, which is the spent bullet found on the victim, in the victim at the hospital. States 5 and 6, which were the projectiles found inside the victim's body at the time of autopsy, which is States 67. Did you do a comparison of those 3 items?
Yes, I did.
And what were your findings?
My conclusions was that the 3 bullets were fired by the same unknown 22 long rifle caliber firearm.
Okay, so all the projectiles and spent bullets found inside the victim all came from the same gun?
Yes, they did.
And can you explain to us how you know that?
Looking at the individual characteristics within the land impressions, using a comparison microscope, you put the evidence side by side, and you start looking for the land impressions and the striations left on them. And when an agreement is found, so agreement means that sufficient striations are matching to each other from both projectiles, then I conclude, take a picture, an image of where the identification was made, and I proceed to write it in my report that an identification was made. And I did this with the 3 bullets.
Now, did you also compare Exhibits 3 and 4, the 222 LR caliber fired cartridge casings, which is States 29, which would be the 22 caliber cartridge recovered from northeast bedroom. No, I'm sorry, that would be the 2 found on scene, the 2 fired casings on scene.
Yes, I did.
Okay, and what were your findings for those?
And both cartridge cases were fired by the same unknown 22 long rifle caliber firearm.
And you're saying unknown firearm, why is that?
The firearm wasn't submitted to with the evidence.
And despite not having a firearm in this case, are you still able to make the determinations that they were fired from the same gun?
Yes, I can.
And that's based on all these individual characteristics and class characteristics we talked about.
Yes.
Now, item 7, which is the 122 LR caliber live cartridge, which is SW1, entered in as States 29. Did you make a comparison of that with Exhibit 3 and 4, which are the 2 22 LR caliber fired cartridge casings found at the crime scene where Jahseh Onfroy was murdered?
Yes, I did.
And what were your findings?
It wasn't a fire cartridge case, it's actually a light firing pin strike. So what that means is that the firing pin struck the base of the cartridge, but not with sufficient force to detonate the ammunition. It didn't fire. So, but the firing pin impressions left were compared to the fire cartridge cases, and it was found that the light cartridge was cycled through the same firearm.
Okay, so again, showing you states 29, which is what we're talking about, being compared to the casings recovered on scene. We are talking about SW1, which is the 22 caliber cartridge recovered from the northeast bedroom. You're saying that that cartridge casing found had to have been fired from the same gun that fired the 2 casings found on scene where the victim was killed.
It wasn't fired, but yes, it was cycled on the same firearm.
Cycled, okay. Was there an intent to fire based on your findings?
Yes,
And how can you tell us that?
because the firing pin impression is on the base of that cartridge, but it didn't strike with enough force to detonate the ammunition.
Now, based on your findings of examining and comparing all of the tool markings on these items we just went over, were you able to determine at least a realm of particular firearms that these were shot from?
Yes,
What were they?
it was a 22 long rifle caliber firearm, either manufactured by Beretta, Remington, Savage, or Rome. This is not a list that excludes every other type of firearm. But how I get to this conclusion is whenever I did the entry, we have a unit, it's called a brass track, based, run by ATF, shorts for NIBIN, National Integrated Ballistic Identification Network. When I enter this casing into
That's
this,
hearsay?
Overruled.
You may answer.
when I enter the casings into this database, the results of possible firearms that fire these casings, they all came into either Beretta, Remington, Savage, or Rome.
But regardless of not knowing which firearm specifically they came from, you can say to this jury here today that they were all shot from the same firearm,
Yes,
or attempted to be shot, I should say, for some.
yes,
Now, were you asked to do a second comparison of some other evidence in this case?
yes, I was.
Okay, and was that on July 18th of 2018?
That's correct.
Okay, and is that done in the same, under the same lab number with just a different date of the lab report?
Yes, the lab number 18-07119.
And what items did you receive in that particular lab report?
I received the previously submitted two fire cartridge cases that were exhibits, for me at least, was exhibit 3 and 4. And additional to that, I received a total of 86 live cartridges. And it was divided into 3 items. The first item had 6 22 long rifle Aguila live cartridge. Second item was 40 22 long rifle caliber Aguila live cartridges. And the third item, another 40 22 long rifle caliber CCI live cartridges.
Now, live cartridges can be ammunition, I'm gonna say it in layman's terms, can be ammunition that's just still in the box and it hasn't been loaded into a firearm yet, correct?
That's correct.
I'm showing you what's been entered into evidence as states 46. This will not fit under that, so I'm going to walk it to you. Permission to approach, Your Honor.
Yeah.
Thank you. Do you recognize this? I think.
Yes, I do. It's bearing my initials and the labels that read 18-1799.
And which items are these that we're discussing?
Exhibits 20, 27, 28, and 29.
Okay. Okay, and are these all those live cartridges, the 46, I think you said that you just discussed?
86
86.
live cartridges in total.
All right. So what was the comparison that you did between the live cartridges, the 86 live cartridges you just discussed, and the two casings that were found on the scene by crime scene detective Clint Williams?
It was a comparison under a comparison microscope in order to see if those live cartridges had any cycling marks in them. For example, magazine lid marks, or a light firing pin stripe, or an ejector mark, anything of that sort. And my conclusions were that no comparison, it didn't have any comparison value due to the fact that no cycling marks were found in any of them.
Now, we talked about a live cartridge in your first lab report where there were cycling marks. So when there's no cycling marks, does that just mean that they have not been loaded into a firearm or a magazine at that point?
Yes,
And with all of the work that you do and the comparisons that you do, is your work also then verified and double checked?
yes. We have a policy of every work,
You may answer.
every case that we do a comparison needs to have a peer review. That means a second examiner goes to the comparison microscope and compares all the evidence that I compared.
Your Honor, may I have a moment? Thank you, Mr. Ruiz-Gonzalez. I have no further questions at this time.
Who's first?
No questions, I'll get Mr. Newsom.
I've asked Ms. Wu.
Very good. Thank you so much. Good morning, sir. How are you?
Good morning.
Could you tell me how it is that you actually get the evidence? How does that work in your office?
Okay, the evidence is submitted first by the agency that submits it. We have many agencies that submit evidence to the central receiving unit that is located inside our crime laboratory. And from there, personnel from the central receiving brings the evidence from their vault to our vault. We have a vault located inside our section of the firearms unit.
Now, could you explain to the jury what an exhibit results report is?
A report basically has all the analysis that I performed and my findings written on the report as well. And the descriptions of all the items that the analysis was performed.
And is that something that you do contemporaneous with the work that you're performing?
The report is the last thing to do. All the contemporaneous notes are being taken at the same time the analysis are being performed. For example, I am firing a gun, I'm writing, as soon as I finish firing the gun, I'm writing that the firearm was operable. If I compare a cartridge case, I put my findings, because I have a computer right next to the comparison microscope as well.
I'm looking at a 10-page exhibit results report in this case. Do you have that with you?
Yes, I do.
I just have a question. If you turn to page 8, I'm sorry, if you turn to page 6, under where it says Exhibit ID 7, you see that?
I'm sorry, Mr.
I'm sorry, I'm so sorry.
No, it's okay. I have it. It's page 6.
Yeah, at the bottom.
Okay, thank you.
You see at the bottom where it says, let me know when you're ready.
May you please repeat the item number?
I'm looking at page 6 of the 10-page exhibit results report. Printed January,
The item in particular?
It's exhibit ID 7. It's on page 6.
Yes, I do have it with me.
Now, under exhibit ID 7, is that the unfired 22 caliber live cartridge?
Yes, it is.
And under the conclusion, can you tell the jury what it says?
It says result NA.
Thank you. No further questions.
Now, Mr. Fulbright,
No cross.
Reed,
Yes, Your Honor. All right, Mr. Ruiz-Fontanez, you were just asked by Mr. Padilla, which is Mr. Williams' attorney, about that page 6 where you said NA under result for exhibit ID 7. Can you explain what that meant?
Do you allow me to look at my comparison notes?
Yes, please.
On my notes, where it says exhibit ID number 2, parentheses, JO11, all my results for the comparisons are gonna be under that page. And it reads the following: Exhibit 7 was cycled in the same firearm as exhibits 3 and 4, based on agreement of striations in the firing pin impression.
Okay, so the NA under that other page that was mentioned is, where does that come from? How did we get then to the actual result you just read us?
That comes because in that page, I did not put my results. My results go in the microscopic comparison results, and that is in a different item where all the notes are taken and explained.
I have nothing further. Thank you, Your Honor.
No recross.
thank you. You are excused. Please do not discuss your testimony with any other witness.
Thank you.
Jake, we need to sidebar regarding scheduling, please.
Okay. So the next witness, I believe, is going to be fairly lengthy, and it's about 1:15, so now is a great time for us to take the lunch break. Also, and hopefully make it so that you don't have to wait back there quite as long while set up or discuss anything that comes up. I'm going to give you an hour and a half today instead of an hour and 15, and have you sitting in the reception for 15. So it's just about 1:15 now. 1:45, we will reconvene. As with each time you break, you're not going in, you've got minutes, opinions, merits, case, you hear all the evidence, arguments, counsel, instructions, and the law on me. Till that time, do not discuss case even among yourselves. During the course of the trial, we'll take regular recesses during which you're permitted to separate and know about your personal affairs. During these recesses, you shall not discuss case with anyone, nor permit anyone to say anything to you in your presence. Anyone attempts to, found me on the jury, ask them to stop, report the matter to one of my deputies. If you see counsel, witnesses, defendants, anyone else associated with the case in the hallway, they will ignore you. They're not being moved. They're following the court's orders. Please isolate yourself from any outside or immediate exposures. Have a great lunch. Thank you. All right, anything else to discuss? All right, let's be back 10 minutes before I close them. So, 1:35.
All right, good morning, everyone. Let's go get started. We're here on case 21 CF 825 State of Florida versus Xxxtentacion. Who's the one appearing on behalf of the state of Florida
Jennifer Duckman, Wisconsin.
and on behalf of the defense?
Rosemary Peoples with Prejudice.
All right, we are here for, I believe we call this a status hearing.
Let Advanced MD transform your practice with unified automation technology.
To select a sentencing date and to address any other motions or matters that needed to be addressed.
That's correct.
I reviewed the file. I did not see any other motions that were filed. I did notice that there were, the witness lists have been filed by both the state and the defense on the 15th. I also did notice that I believe 2 days ago, there was some objections to a subpoena. I don't know if we can address that today.
I advised our attorney that I believe he wanted to withdraw it and that there was a hearing today, but I don't believe that he had the ability to appear today.
Okay, so we'll take that up if there, if we need time for that, just let me know. We'll certainly make time to address those matters if necessary. Are there any other motions that we need to address today?
No, Your Honor, none at this time. The state has set some deposition dates for March 3rd, and I believe there's some other dates coming. And then after that, we'll be in a position to then, if necessary, file a motion. So we have to actually go through some depositions before the defense is in a position to file.
Okay, that's fine. Just let me know. We will certainly make time available. I did review the witness lists. Let's talk about sentencing dates. Have your calendars available. I know that there was some matters in March that would preclude us from setting it in March. We're looking at April. Is that still?
Well, we had talked potentially about early the week of March 20th. The 23rd on is a problem. And I know when we move, I think Ms. Peoples and I are in agreement if the court has time, for potentially.
21st and 22nd.
Yeah, the 20th, 21st, 22nd, something like that.
Of March?
Yes, sir. Because once we get into April, at least I know with Mr. Johnson and I's calendars, and we have the one conflict with a family member not being able to be here, you know, we all have trials that start backing up beginning in April. So I'd like to accomplish it in March if we can.
I can certainly do the 20th, 21st and 22nd. Those are 2 days that's the Tuesday and Wednesday of that week.
Would the court be available maybe to start the afternoon of that Monday afternoon?
Possibly. That's jury selection day, so that's.
It's just up in discussion, the way the witness lists are now, we're thinking we might go over the two. That's why I was thinking.
From the state's perspective, will be a day or less than a day. I know my list is extensive, but I'm not necessarily calling all those people. So I think I can get my portion done certainly in a day, let alone potentially short of a day. So then it kind of switches to what most people think.
Right now, a day and a half to 2 is where I am. But that may change again. I'm in a similar position where we might not be confident with this.
The 23rd is not available.
Well, as long as we start it in that week, if the court would allow potentially a viewing over Zoom, maybe at the end of the hearing for the person that's out of country, we can certainly keep coming.
Let's plan that then, and we'll reconsider whether or not we can do it start that Monday afternoon. And I'll just reach out to you both and we'll see if we can potentially start a little bit early. I need to look at all of our trials that I have currently scheduled, and I have to find out if there's how many we have, and then if I have other judges that can select juries for me. That's kind of the issue that I run into. But I think I can probably accommodate that. But for right now, let's plan on the 20th and 21st and 22nd. Those days are definite, and then we'll either start early on the 20th, or we have to expand it to the 23rd. But I'll let y'all know that by next week.
Thank you.
Okay, does that work?
Yes.
All right, do we want to address any other matters today, or?
The only other thing, Judge, we were sort of thinking, or wondering about is, you already may not know yet, but procedurally, do you know if your honor anticipates making a ruling, or if it's a situation? I know there's certain written findings that may have to be made. I don't know if you've thought that far, if you're gonna ask some memos or, and come back sentencing date, or if you even know yet, just also for future planning.
As far as you're talking about under 921.1401.
Correct. Yeah, and the rule, so 3.781, basically, it sounds like as long as your honor makes specific findings on the record, and so it just says on the record, which obviously means orally, as to the factors, that's fine. You have to make written findings about the sentence review hearing, which wouldn't be extensive. So yeah, I mean, it looks like you can do a verbal recitation of that, and that is okay for the record. I just wasn't sure how your honor wanted to proceed.
I would anticipate, most likely doing a written order.
Okay.
That's kind of where I'm at. So if you all wanted to do something in writing, that's fine. If you want to submit something in advance, some type of a memo, a written memo. Because my intention is to decide the sentence that week. I don't want.
That was the question.
Yeah,
If you
I do
wanted
not
to.
intend to
Okay,
delay.
that helps. Okay, I can figure that out.
Yeah.
Meaning you would announce the sentence on the 23rd, 22nd.
Whenever we finish, yeah, that would be my intention is to go ahead and rule then. I would not anticipate needing to do that.
And would there be a deadline for councils to provide a memo, or do you not?
Well, when you will, what's reasonable?
Friday.
I mean,
Well, that's spring break, so I don't know if you'll have plans, but
if your honor intends on ruling after the hearing, I'll reserve my arguments for, essentially closing or an argument to the court. I may not need to do a memo in that situation. I just wasn't sure if you're gonna require it, and that would find it out different. It's not required.
well, okay.
I told them, hey, Mom, I spent 8 years on this degree, but I hate it, and I really want to change jobs. I'm sorry, I know this sounds crazy. Judge Smith presiding.
Have been filed by both the state and the defense on the 15th. I also did notice that I believe 2 days ago there was some objections to a subpoena. I don't know if we can address that today.
I advised our attorney that I believe he wanted to withdraw it and that there's a hearing today, but I don't believe that he had an ability to appear today.
Okay, so we'll take that up if we need time for that. Just let me know. We'll certainly make time to address those matters if necessary. Are there any other motions that we need to address today?
No, Your Honor, none at this time. The state has set some deposition dates for March 3rd, and I believe there's some other dates coming. And then after that, we'll be in a position to then, if necessary, file a motion. So we have to actually go through some depositions before the defense is in a position to file.
Okay, that's fine. Just let me know, and we will certainly make time available. I did review this list. Let's talk about sentencing dates. Look at the calendars available. I know that there was some matters in March that would preclude us from setting it in March. We're looking at April. Is that still correct?
Well, we had talked potentially about early the week of March 20th. The 23rd on is a problem. And I know when we move, I think Ms. Peoples and I are in agreement if the court has time, for potentially.
21st and 22nd.
Yeah, the 20th, 21st, 22nd, something like that.
Of March?
Yes, sir. Because once we get into April, at least I know with Mr. Johnson and I's calendars, and we have the one conflict with a family member not being able to be here. We all have trials that start backing up beginning in April, so I'd like to accomplish it in March if we can.
I mean, I can certainly do the 21st and 22nd. Those are 2 dates that's the Tuesday and Wednesday of that week.
And would the court be available maybe to start the afternoon of that Monday afternoon?
Possibly, that's jury selection day, so that's, I
It's just
prefer.
in discussion, the way the witness lists are now, we're thinking we might go over the two. That's why I was thinking.
From the state's perspective, will be a day or less than a day. I know my list is extensive, but I'm not necessarily calling all those people. So I think I can get my portion done certainly in a day, let alone potentially short of a day. So then it kind of switches to what most people think.
Right now, a day and a half to 2 is where I am right now. But that may change again. I'm in a similar position where we might not be calling everybody else.
The 23rd is not available.
Well, as long as we start it in that week, if the court would allow potentially a viewing over Zoom, maybe at the end of the hearing for the person that's out of country, we could certainly keep going.
Let's plan that then, and we'll reconsider whether or not we can do it start that Monday afternoon. And I'll just reach out to you both and we'll see if we can potentially start a little bit early. I need to look at all of our trials that I have currently scheduled, and I have to find out if there's how many we have, and then if I have other judges that can select juries for me. That's kind of the issue that I run into. But I think I can probably accommodate that. But for right now, let's plan on the 20th and 21st and 22nd. Those days are definite, and then we'll either start early on the 20th, or we have to expand it to the 23rd, but I'll let y'all know that by next week.
Thank you.
Okay, does that work?
Yes.
All right, do we want to address any other matters today, or?
The only other thing, Judge, we were sort of thinking, we're wondering about is, Your Honor may not know yet, but procedurally, do you know if Your Honor anticipates making a ruling, or if it's a situation? I know there's certain written findings that may have to be made. I don't know if you've thought that far, if you're gonna ask for memos or and come back sentencing date, or if you even know yet, just also for future planning.
As far as you're talking about under 921.1401.
Correct. Yeah, and the rule, so 3.781, basically, it sounds like as long as Your Honor makes specific findings on the record, and so it just says on the record, which obviously means orally, as to the factors, that's fine. You have to make written findings about the sentence review hearing, which wouldn't be extensive. So yeah, I mean, it looks like you can do a verbal recitation of that, and that is okay for the record. I just wasn't sure how Your Honor wanted to proceed.
I would anticipate most likely doing a written order.
Okay.
That's kind of where I'm at. So if you all wanted to do something in writing, that's fine. If you want to submit something in advance, some type of a memo, written memo. Because my intention is to decide the sentence that week. I don't want.
That was the question.
Yeah,
If you
I do
wanted
not
to-
intend to
Okay,
delay.
that helps. Okay, I figured that.
Yeah.
Meaning you would announce the sentence on the 23rd, 22nd?
Whenever we finish, yeah, that would be my intention, is to go ahead and rule then. I would not anticipate the.
And would there be a deadline for counsels to provide a memo, or do you not?
Well, when you will, what's reasonable?
Friday before?
I mean, if,
Well, that's spring break, so I don't know if you'll have plans, but.
if Your Honor intends on ruling after the hearing, I'll reserve my arguments for, essentially a closing or an argument to the court. I may not need to do a memo in that situation. I just wasn't sure if you're gonna require it, and that would out different. It's not required.
Well, okay.
So obviously we know what we think the testimony will be, but.
Right.
But no, I think oral argument is fine for the state.
It's fine, Your Honor.
Okay.
In the past, on some of the other cases, I would then, after the sentencing, just supplement additional memorandums or exhibits with the intention for the review in 25 years, if the court would allow that. But if the court doesn't need a written memo from the defense in advance, we're fine with making it work.
Yeah, I guess if we think there's cases we're gonna rely on, we can submit those prior to the hearing, so you have that, but I don't think that.
Yeah, I mean, the only, I may want, maybe a day, I may take a day break if I need to. But I'm not going to drag this out any longer than necessary. So I don't want to, go through a sentencing hearing and then say, all right, now I'm going to take 3 more weeks and come back. I'm not going to do that. So my intention would be to have the sentencing hearing and then rule that week. So maybe, maybe we have the sentencing hearing the 21st or 22nd, and then we have to come back on the 23rd or 24th. To give me a little bit of time. Obviously, I do need some time to just absorb everything.
Yes, sir.
And contemplate everything, but I'm not going to pass it off for any more than a day or two.
Understood.
Understood, thank you.
Let me address one. I know that there was some discussion about mental health experts and whether or not they would be testifying. I did not see any on your list. Is that?
That's correct, Your Honor.
Okay.
And that's, again, I don't anticipate that changing, I just need you to post the state expert.
Okay. Let me just address, and I just want to make sure we talk a little bit about that decision. So Mr. Fucci, let me just talk to you for a minute, sir. There's a, you heard us discussing what's going to happen in March, and we're going to be coming back for a sentencing hearing. And your attorney has hopefully not already, will be talking to you soon about what's known as section 921.1401 of the Florida statute. That is basically a statute that lays out certain factors that the court must determine and consider for a person who is under the age of 18 if the court were to consider sentencing you to life in prison. And the factors, and I'm just going to read it, I'll just read it for the record just so you understand it, and then obviously you're going to talk to your attorneys, I'm sure you probably already have, but I want to make sure that you are still talking to your attorneys about this, because there's something that your attorney has indicated to me that they're still talking to you about the decision about whether or not they're going to present evidence of in the nature of either testimony or reports from any type of a mental health professional. So let me just read this out loud, and I'm not going to probe into your client as far as what his understanding of this is, counsel, but I just want to make sure that it's at least on the record for him so he knows things that he should be asking and talking to you about. So Mr. Fucci, it reads, upon conviction or adjudication of guilt of an offense described in 775.082, and it lists out several statutes, of which the one that you have now entered a plea to is included. The court may conduct a separate sentencing hearing to determine if a term of imprisonment for life or a term of years equal to life imprisonment is an appropriate sentence. In determining whether a life imprisonment or a term of years equal to life imprisonment is an appropriate sentence, the court shall consider factors relevant to the offense and the defendant's youth and attendant circumstances, including but not limited to. And then it lists out a bunch of factors. I'm going to read those to you real quick, okay? A, the nature and circumstances of the offense committed by the defendant. B, the effect of the crime on the victim's family and on the community. C, the defendant's age, maturity, intellectual capacity, and mental and emotional health at the time of the offense. I'm going to come back to that one, okay? D, the defendant's background, including his or her family, home, and community environment. E, the effect, if any, of immaturity, impetuosity, or failure to appreciate risks and consequences on the defendant's participation in the offense. F, the extent of the defendant's participation in the offense. G, the effect, if any, of familial pressure or peer pressure on the defendant's actions. H, the nature and extent of the defendant's prior criminal history. I, the effect, if any, of characteristics attributable to the defendant's youth on the defendant's judgment. And J, the possibility of rehabilitating the defendant. So those are all the factors that I would have to consider in determining what the appropriate sentence is, and if I determined that the life sentence was appropriate, those are all things that I would have to be thinking about, considering. I want to make sure that you understand that. You need to be talking to your attorney about that. Do you understand that, sir? Yes, Your Honor. All right. One of the things that, as I mentioned, is the defendant's age, maturity, intellectual capacity, and mental and emotional health at the time of the offense. Now, that may be something that you and your attorneys decide. If there's some experts or mental health experts who you have been talking to who, at this time, are not listed on your witness list. Do you understand that?
For the second year.
Okay. Sure.
Familiar with the victim in order to have the victim identified.
Yeah.
So I'm going to do that today. I am supplementing discovery for the state intends to call the family member Deandra Ellis. For the sole purpose of identity, I expect it to be just a few questions. I also have a Ori Tennis motion in limine that I want to address regarding her testimony. There have been other pretrial matters regarding other potential motives and discovery regarding other family members and anything having to do with things that happened since Jahseh Onfroy has died with his estate, things like that. I am asking for this court to limit the testimony just very strictly to the scope of identity, which is all I'm going to ask. I don't think, for a variety of reasons that I want to put on the record, it would be appropriate. Number one, I would argue it's harassment under this circumstance to try to backdoor that in through an identity witness. This is a grieving family member, and it would be highly inappropriate to ask those types of questions of this particular witness. I'm also trying to limit the fact of upsetting the witness, because already the witness is going to have to see a very upsetting photograph based on the fact that there's been no stipulation. And I don't want to cause any issues regarding that. And I've asked for motions in limine before to be strictly adhered to, but for this one, Judge, I'm saying in advance, that's what I'm doing outside the presence of the jury. I'm going to be vigorously objecting, even if it's like a question that, for example, the question is like, well, isn't it true that, and then a string of what the counsel wants to get out there, knowing that the state is going to object and it will likely be sustained just so that they can get their question out there. I'm putting that all out there because I think, especially given the nature of the testimony, the nature of the witness, it would be highly inappropriate. And so I just wanted to put all that on the record, and in case there were any issues last minute.
Judge, we object to the late disclosure of this witness. We are now in day 12 of trial. This witness identity is an issue the state has to prove in every trial, and they have to prove it in this trial. We have not had an opportunity to depose this witness to see what else, if anything, she knows about this homicide. And now the state is attempting to curb any potential cross-examination of the witness. And so we object to the late disclosure. We ask that this witness be stricken, or that the case, or that she not be called, and or the case be continued until such time as we can take her deposition.
Let me ask So Mr. Boatwright's also not willing to stipulate to identity? Because I thought you were, I thought it was only Mr. Diaz.
No, we are not willing to stipulate to identity.
Adjourn, Judge.
Yeah, and we don't know who she is, what her relationship is. We don't know if she's been here in the courtroom during any part of this trial. I think there is real harm to this.
Real harm from a immediate family member coming in to identify the person. That's your argument.
Yes, Judge, we don't also don't know what else she knows about the case. The state has just listed her on, again,
The state said they're
11 or
limiting
12.
their direct to the sole question, the person being called for the sole purpose of identity.
And that might be the state's reason for doing so, but we may have additional questions about what this witness knows about the homicide. And we don't know because we haven't taken her deposition.
Here's what we can do.
We did take Cleopatra Bernard's deposition, and Jahseh Sanchez's deposition, the two individuals who we identified from the witness list as being the most likely to be called to offer identification in the case.
Interesting. Judge, if I may, this witness is the sister of the victim's father. So it is the paternal aunt, a blood relative, the paternal aunt of the victim. Jahseh Onfroy was her nephew. Yes, she has been present, as she's entitled to be under the Florida Constitution, for every day of this trial. She's watched it. She's currently present in the courtroom. And there's actually an exception to the rule as to whether or not a witness, so if it was a witness that the state had listed and as a family member is next to kin, there's an exception. And she's entitled to be present. As far as what she may or may not know about the homicide, the state has never listed her prior to this as having been involved with the homicide, having known anything about the homicide. And I would have to do that under my obligations as an officer of this court and under the rules of civil procedure, because she doesn't know anything about the homicide. The sole purpose as to why I'm listing her is because, for whatever their reasons are, which in my 17 years of practicing, I've never had a defense not stipulate to identity, especially when certainly they've made their whole defense about the identity of the victim and the fact that he was a celebrity and it could have been Drake and all these other people. And so, okay, fine. They don't stipulate to that simple fact, not a problem. But to address that, as I know to do in my case in chief, I've listed her as a family member for several reasons. She's present and I don't have to, I could just, it'll take 5 minutes, I believe, is my testimony, and then we can resume with the other lined up witnesses that we've had. If they choose or want to depose her, judge, she's present. We have a court reporter. State has no objection. If they want to ask questions or depose her, they're more than entitled to. I think that some of the arguments that are being made are disingenuous because it is an identity argument. They've argued every which way from Sunday, including in cross-examination, opening statements that the victim is Jahseh Onfroy. They've referred to him as such. They've referred to him as XXX. They've referred to him even in voir dire in terms of how we picked the jury. But now they are now saying they're not stipulating. So, okay, fine. We are entitled to prove our case however we prove it. We are entitled to call whoever we need to call. So if that was their calculation, that they thought that they were going to force me to call the mother of the victim to the stand so she can look at an autopsy photo of her son so that they can get into questions to harass her, I guess it didn't work, but I'm sorry, I can prove my case however. So if Your Honor is allowing us to do this, then I would ask for that limited motion in limine, and I would proceed that way, and I can resume with the normal schedule that I advise the court of.
How much time do you need to pose this witness on the issue of identity?
I'm Bill Brink, Moran Heating and Air Conditioning. Well, it's official. The groundhog has seen its shadow, which means we're not going to see summer for a long time. But not to worry, we're prepared.
Cut! Mark, what do you think you're doing here?
Well, I know you're super busy. I was just telling our customers about a great heating offer.
Get out of here. I got this. I'm the real Bill bringing Catamaran Heating, and for Fast Heat, we have a deal for you. Get Fast Heat with a new Lennox furnace, installed for as low as $37.95. Call or visit catamaranheating.com today.
Peggy 16.
For other family member depositions, and I just don't want this to go off the guardrails.
This was a witness that was not listed until day 11 of trial.
I'll do a Richardson hearing on it. I don't find the state has indicated why they're calling this witness, and the late disclosure of a person available for an identity, the court does not find to be a willful or hide-ball kind of delay. You're being offered an opportunity to question the witness prior to the testimony on that. What prejudice is there to you on the issue of identity? And again, you know, I'm asking you not to be disingenuous with the court. You're under some belief that the victim in this case is not Jahseh Onfroy. That's not your position the entire time. You're somehow confused by that, or that has altered your preparation of the case, that the aunt of the victim might know his identity.
Judge,
please explain this.
Yes, Judge, as Mr. Boatwright's counsel, and he has a Sixth Amendment right to counsel, and I am very proud of the fact that I will challenge each and every element and hold them to their burden of each and every element of the case in this trial. I'm not going to admit to anything unless it benefits Mr. Boatwright. And in this case, conceding that particular element does not benefit Mr. Boatwright. And so we won't do it. We're going to hold them to their burden and hold them to the rules of evidence and the rules of discovery. They didn't file this witness prior to the discovery deadline. They didn't file it prior to trial. If we are going to be forced to cross-examine this witness, we want an opportunity to know what it is she's going to say about and what she knows about Mr. Onfroy and anything that she may know about this homicide prior to trial. And so we are asking that the court either strike her or continue the case until we can take a full-fledged deposition.
I'm going to give you the opportunity to speak to her now before she testifies. I can't imagine that you can make an argument how your preparation in this case would be materially different if this witness had been presented previously on this issue. Mr. Padilla, you're joining Mr. Boatwright?
I join.
Mr. Rares, are you joining?
Judge, we have been prepared to stipulate. We are concerned. We understand co-counsel has a right to request this happen this way. We're concerned with any emotional reaction the jury might see, as that would certainly prejudice Mr. Newsom and not, in our opinion, gain any advantage for any side other than the state. So we would stipulate to ID as behalf of Mr. Newsom.
All right, I will allow you, Mr. Rares, at the time you're offered cross-examination to let the jury know that you've stipulated to the identity.
Thank you.
I actually have a written stipulation if that can be signed by Mr. Rares and Mr. Newsom.
Certainly.
And I'm asking then, Judge, as I normally would, for that stipulation to be read into the record on behalf of Mr. Newsom.
Shall be.
No, Judge. You can sign it, just say that was just.
I had it printed. Hold on one second, Your Honor. I had it printed. I'll just reprint it again. I don't know what I did with it. That's okay. I'll reprint it again. It'll take 2 seconds.
Tell the jurors to relax for a few minutes and do consult.
No, and at the moment that happens, we're going to request a sidebar.
Just one moment, Your Honor. I'm reprinting Mr. Newsom's stipulation.
Yes.
No, it's literal, it's printing. This is, I was gonna say, I have my stuff. You touched it. I'm not moving. Everybody tell you. Mr. Reyes, actually, it's yours, so if you want to take a look at that, please. He's going over the stipulation with his client to sign. Miss Ellis is here and available for the deposition to start. And I would ask that the court reporter who's present, Miss Chin, who I believe is with Boss Reporting, to be allowed to handle the matter, the deposition, in open court.
Judge, I understand the limitations of the deposition here in open court. Would the court allow us an opportunity maybe tomorrow morning to depose her beyond the parameters?
No.
Your Honor, may I approach?
Right.
This is the stipulation on behalf of Mr. Newsom signed by the state, Mr. Newsom and Mr. Reyes.
And give me a second on that. Let me, just for purposes of the deposition portion, I'm going to direct that not be live streamed because deposition is ordinarily not part of the public court proceeding. It's being done here for convenience. It's being done in my presence to expedite any objections, but it is not part of the public record and will be treated like a sidebar. But before we do that, let me just address the stipulation. Mr. Newsom, stand up, please. Raise your right hand and be sworn. Swear the testimony you're about to give in the case non-hearing should be the truthful truth and nothing but the truth, so help you God.
Yeah.
Put your hand out, state your full name, spell your last name.
Trayvon Newsom, TRAYVON,
You are a defendant in this case?
Yes.
All right, your attorney has indicated that you are willing to enter into a stipulation in this case, is that correct?
Yes.
All right, you're not required to enter into a stipulation, you understand that?
Yeah.
And, you know, if you ask not to, it would not happen, but your attorney and you have had an opportunity to discuss this.
Yes.
And this is what you wish to do.
Yeah.
All right, and I see a written stipulation with your signature on it, is that correct?
Yes, right.
And you had an opportunity to read it over and discuss with your counsel?
Yes.
And this is what you wish to do?
Yes.
Thank you. You can be seated. I will mark the stipulation as court exhibit. Court exhibit 4 will be marked as that, and at the appropriate time, you may ask for me to read that stipulation. And there's an instruction on stipulations, which I will also.
Okay, so what I'll probably do, Judge, is before the state calls Miss Ellis, I will ask for the stipulation to be read so that the jury is aware that Miss Ellis is being called for which case.
Yes.
Okay.
For which?
Or which defendant, I should say.
Correct.
State's ready for the deposition, so Miss Ellis is present, so.
Okay. So
right and not agreeing to another because he exercised his rights, it is a violation of Mr. Boatwright's due process for this stipulation to be read to the jury. And let's be honest about why they're doing it. They want the jury to hear that Mr. Boatwright is somehow forcing this witness to get on the stand. And that is not the truth. And so we object.
And Judge, I join in considering the late disclosure of this witness. I believe it was my client's right to have her deposition taken, and once he was satisfied, he's stipulating as well. We believe that it's unfairly prejudicial to mention the fact that Mr. Newsom agreed, and simply because he, we undertook the deposition to single him out as someone that's not stipulating because it's not actually correct.
Prior to taking the deposition, prior to the name of the witness being announced, you indicated you would not stipulate. So that has nothing to do with that, sir. Thank you.
State's ready to proceed, Judge.
All
You're ready.
right, very much. Issues. State, you may proceed.
Thank you, Your Honor. Prior to the state calling its next witness, if I could please ask the court to read the stipulation of the deceased victim on behalf of co-defendant Trayvon Newsom, please.
Yes. All right, ladies and gentlemen, first let me instruct you of the following. When parties agree that certain facts are true, we call that a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of those facts, as with any fact in the case, is for you to decide. In this case, the state of Florida and counsel for the defendant Trayvon Newsom, with the express written consent of the accused Trayvon Newsom, have stipulated to the following facts that you must accept as true, but only with respect to defendant Newsom, and they are as follows. The state attorney, defendant, and defense counsel stipulate as follows. Jahseh Onfroy is the deceased person named in the indictment and identified by Broward County Medical Examiner number.
That's enough! Puts him down and lands inside.
I'll be judging the PFL.
To an established fact. You're next.
Thank you, Your Honor. The state calls Ms. Deandra Ellis.
Raise your hand if you're sworn. Sorry. Thank you.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you, may be seated. Please state your full name and spell your first and last name for the record.
Deandra Ellis, DeAndraEllis.
You inquire.
Thank you, Your Honor. Good afternoon, Ms. Ellis. If I could please ask for you to introduce yourself to the jury and how you know or are related to the victim in this case, Jahseh Onfroy.
Good afternoon. My name is Deandra Ellis. I'm Jahseh's fraternal aunt, his father's sister.
So safe to say that you have known Jahseh all of his life.
Yes, ma'am, I have.
And I'm sorry to have to show you this, but I'm going to show you what has been marked for identification as states XXX. May I please approach the witness?
Do you have an objection?
As I was stating, I'm sorry to have to show you this. I'm showing you what's been marked for identification as states XXX. Could you please take a look at the photograph? Do you recognize states XXX?
I do.
How do you recognize it?
That's right here.
And you recall that as being the same person that you've known his entire life as the son of your brother.
Yes, ma'am.
At this time, I'd move into evidence states XXX as 69.
No objection. Nothing additional. No objection. George?
No objection.
Without further objection, what was previously referred to as states XXX for identification shall be received in evidence as states 69.
Yes, Your Honor.
You
Permission to publish?
All right, and let me address that this photograph, along with, should we get to any autopsy photographs, may be displayed, published just to the jury, or if it's going to be put on the projector, that it shall not be captured by the video camera and shall not be broadcast. So I'll make that clear. Thank you.
No further questions, Your Honor.
Cross-examine on behalf of Mr. Boyd,
No, Judge, we also stipulate Mr. Onfroy's identity.
on behalf of Mr.
No, Judge, we stipulate as well.
Marie.
No, Your Honor, I believe the only stipulation that we had was the one that Your Honor read into the record.
Thank you, you are excused. State, call your next.
State calls Dr. Yuri Boyko.
Dr. Please raise your right hand, be sworn.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated. Please state your full name, spelling your first and last name for the record.
I'm Dr. Yuri Boyko, first name I-O-U-R-I, last name B-O-I-K-O.
You may inquire.
Good afternoon, Dr. Boyko.
Good afternoon.
If you could please introduce yourself to the jury and tell us where you work, sir.
I'm Associate Medical Examiner in Broward County Medical Examiner Office.
How long have you been an associate medical examiner with Broward County?
14 years.
And in total, how long have you been an associate medical examiner?
18 years.
Where did you work prior to Broward County?
In Charleston, West Virginia.
Now, if you could please detail some of the duties that you have as an associate medical examiner.
My duty is to perform external examination and autopsy of the body to determine cause and manner of death.
Okay, so that doesn't just include homicides. It could also include any type of death in addition to homicides, correct?
Yes.
What type of educational background do you have? You could detail that for us.
I received my MD and PhD in Ukraine. I came to US in 1994. I worked as researcher in MD Anderson Cancer Center in Houston, Texas. After that, I passed my exams and was accepted in general pathology residency in University of Texas Medical School in Houston from 2000 to 2004. After that, it was 1 year fellowship in forensic pathology in Harris County Medical Examiner Office in Houston, Texas. After that, I was working as Associate Medical Examiner in Charleston, West Virginia. And from 2008, I'm working here in Broward County Medical Examiner Office.
And what type of licensing do you hold in order to perform autopsies in the state of Texas? The state of Florida.
I have a medical license in the state of Florida, and I'm board certified in general pathology and board certified in forensic pathology.
How long have you been certified in those specific disciplines?
12 years.
And what was the training that you had to undergo? I heard you mention something about you did a residency as well. If you could detail that for us.
Yes, I received my medical education in Ukraine, as I said, but in USA we have to repeat our study. So I was accepted in general pathology residency. It was 4 years in Houston and 1 year fellowship in forensic pathology.
Do you also have to stay up to date with continuing education credits?
Yes.
How many?
Well, every year we have just continued education.
Okay, so every year?
Yes,
Okay. And are you current on that?
yes.
How many autopsies have you performed to date?
Approximately 4,000.
4,000.
Yes,
And you've testified previously as an expert in forensic pathology in court?
yes.
How many times?
200.
Tender, Your Honor?
Mr. Wonder?
No, thank you.
No, Judge.
No, Your Honor.
All right, once again, ladies and gentlemen, let me instruct you that Dr. Boyko has been tendered to you as an expert by the state in the field of pathology.
Forensic
pathology. Expert witnesses are like other witnesses, with one exception. The law will permit an expert witness to give an opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Whether or not a witness is an expert is a decision for you to make. The court is not allowed to take a position on that matter. Unlike any other witness, you may properly believe or disbelieve all or any part of an expert's testimony.
Thank you, Your Honor. Dr. Boyko, I'm going to direct your attention to Broward County Medical Examiner case number 18-1808 for autopsy. Do you recognize that number?
Yes,
How do you recognize that number?
because I performed autopsy in that day.
Okay, and so each case or autopsy that is performed at the medical examiner's office is given a unique identifying number.
Correct.
And when was that autopsy performed for case number 18-1808?
It was on June 19, 2018.
Okay, now, as part of your duties, if there is a deceased victim that is on scene, meaning they weren't transported from the scene and died later at the hospital, do you sometimes respond to the scene in order to review the scene with an investigator?
Yes.
Okay, in this case, you didn't do that, correct?
No.
And why is that?
Because he was already in hospital.
Okay, and so when the victim was at the hospital, is that where the victim was pronounced deceased?
Yes.
Does the hospital that the victim died at relinquish custody of the victim to the medical examiner's office for purposes of an autopsy?
Yes.
Now I'm going to show you what's been marked for identification as a composite, states RRR, 9 photographs. Back approach, Your Honor. And actually, I'm also going to approach with what's been entered into evidence as State 69 as well. Do you recognize, there's 10 items in front of you. One is State 69, and the other 9 items are identified as States RRR. Do you recognize States RRR, the 9 photographs?
Yes.
How do you recognize it?
The photographs were taken during autopsy. When I perform autopsy, our photographer makes photographs.
Okay, and so your autopsy is memorialized with photographs?
Yes, it's looking for every case.
Okay, and do the photographs fairly and accurately represent what you recall as on 6/19 when you performed the autopsy in case number 18-1808?
Yes.
At this time, Your Honor, I move into evidence what's been marked for identification as states RRR as states 70.
No additional objection.
No objection.
No objection, Judge.
No further objection. What was previously marked states RRR for identification shall be received in evidence as states 70, a composite of 9. And you may publish the bill.
Thank you, Your Honor. Okay. I'm gonna first show you what has been entered into evidence as states 70. It's picture 1 of 9, and then I'm gonna publish it to the jury. So I'll show you first. Permission to continuously approach the witness. Thank you. You've seen 1 of 9 before, correct?
Yes.
Okay, so now that you've seen it, I'm gonna publish it to the jury. Can you tell us what is states 1 of 9?
Usually we receive body from for homicide cases in plastic body bag and sealed with red plastic seal.
Who has permission or the authority to break that seal?
Forensic pathologist who is on duty. In that day it was me.
Okay, so only the forensic pathologist, correct?
Yes.
All right, and is that a way to be able to make sure that the remains of the decedent are not disturbed, and also if there's any evidentiary value of anything in terms that you can use in the autopsy, that also isn't tampered with?
Yes.
Dr. Boyko, I'm showing you what's already been entered into evidence as states 69. Now, if you could explain what we are looking at in states 69.
Yes, photographs which was taken during autopsy, photographs of decedent.
Okay, so it's a close-up of the decedent in this case. Now, state 69 has already had has been identified as the victim is Jahseh Onfroy in this case. And so what is important or significant with regard to the placard that's under Mr. Onfroy that we can see?
No, this number which attached to everybody which can come in our office, so it's identification number that is exactly this.
Okay, that's the unique identifying number that you testified about just a moment ago. And so that everything that you're testifying to relates back to Mr. Onfroy in terms of that number?
Yes.
Okay. And is that number depicted in all of the photographs that's in state 70?
Yes.
Now I'm going to show you what's already been entered into evidence as states 2 of 9 of states 70. If you could please take a look at 2 of 9. Tell us what you're looking at, please.
It's their decedent.
Okay. Now, why is it that certain photographs are taken in terms of the angles? Why is that important to you to be able to document that? And I'm going to show the jury as you're testifying about the overall photograph.
Well, these photographs show that decedent had some gunshot injuries and he had surgical procedure.
Okay. Now, one of the things that, with respect to surgical procedure, is that important for you to notate that the victim came from the hospital and had surgical procedures so that you can differentiate maybe what the hospital did versus what may have happened as part of the incident that caused this victim's death?
Yes.
Okay, and did you notate that?
Yes.
Now, I see as part of 2 of 9 of state 70, there are some rulers and some measurements and things that are laid out next to the victim. Why is that important for you to notate that?
These measurements help to determine where is exactly location of the wound, comparing the top of the head, compare with midline, so we can localize gunshot wound more precisely.
Okay, and so with respect to orienting ourselves and what we're going to look at, ordinarily when we are looking at the autopsy photos, the placard is placed where? Near the head?
Yes.
And is that to help as someone's looking at the photograph to be able to orient themselves as to which part of the body they're looking at, correct?
Correct.
And when you are talking about measurements and some of the locations of the wounds that you're going to talk about, first of all, is there a standard way of referring to specific parts of a victim as you're looking at the victim? In terms of like this?
Yes.
Okay, so I'm positioning myself in a way that will help you explain that. And so why is that significant that you always refer to the victim, any victim, in this way?
We call it normal anatomical position.
Okay, so this is the normal anatomical position. So when you're saying, for example, left, you don't have to differentiate your left or the jury's left. It's always going to be the same for each autopsy, correct? Okay. I'm showing you what's been marked as states 3 of 9 of state 70. If you could please take a look at it.
Yes.
And as I'm publishing this to the jury, can you tell us, I see that there are 3 placards that are labeled A, B, and C next to wounds. Can you first tell us where are these placards located? And if we're looking at or considering that the picture is anatomical, where are the wounds located?
These 3 wounds located on the left shoulder, left side of the neck.
Okay, and so am I pointing at the right direction of where they're located?
Yes.
Okay, so that's always going to be anatomical position, left shoulder, just under the neck. Okay, now what does the placard A represent? I'm going to go through each one.
We call it gunshot wound A, just to distinguish A, B, C, different gunshot wounds.
All right, so you first, is one of the things that you do is you actually count how many wounds you determine are present for the victim, correct?
Yes.
And are you able to determine what caused the wounds and the path of the wounds or whatever injured the victim?
Yes.
Okay, and placard B, what does that represent?
It's gunshot wound B.
And placard C?
Gunshot wound C, number 3.
Okay, so based on the fact that there's 3 separate placards, did you determine how many times the victim was shot?
3 times.
Okay, now, with each wound, did you actually examine each wound?
Yes.
And I'm gonna show you what's been entered into evidence as states 4 of 9. And what is the significance, if you could tell us what the significance is in terms of a wound, for example, an entrance and an exit, and what that distinction is in terms of the wounds that we're looking at?
Well, exit is exit wound is wound where projectile is exiting from the body. Entrance wound is where projectile entering the body. So these 3 gunshot wounds, it's gunshot wounds of entrance. It's where bullets came into the body.
Okay, so all 3 are separate entrances.
Yes.
So 3 separate bullets. And was there an exit wound to correlate with entrance wound A?
No.
Does that mean that there was a projectile that remained inside Mr. Onfroy?
Yes.
Was there an exit wound to correlate with entrance wound B?
No.
Does that mean, and I'm showing the jury 4 of 9 as we're talking about it, does that mean that the projectile remained in Mr. Onfroy?
Yes.
For wound B? Was there an exit wound to correlate with entrance wound C?
It was partial exit wound. Partial means that projectile somehow separated and part of that projectile exited. So it's partial exit wound. And the rest of projectile was found in the body by clinician.
Okay, and I believe that we have entered that into evidence. As states 37, I know you didn't collect this. but is this what you're potentially referring to as partially that was found and retrieved by a clinician, meaning an ER doctor?
Yes.
Okay, and an ER doctor that was trying to perform life-saving measures on Mr. Onfroy at the hospital?
Yes.
Now let's start, if we could, talking about entrance wound A. And I'm showing you what's been entered into evidence as 5 of 9 of state 70. Just take a look at it if you could, doctor, and I'll let the jury finish looking at 4 of 9. Please tell us what we're looking at in 5 of 9.
It's entrance wound A.
So it's a close-up of wound A.
Yes.
Now, what, if anything, was significant or remarkable to you about wound A? What was the size of wound A?
Wound A was 1 centimeter in diameter, and it was located 27 centimeters below the top of the head and 9 centimeters left of anterior midline. So left of anterior midline.
Okay, so using myself again,
Yes.
and if you could, with your pen, if you could point to me.
It was right here.
Right here?
Yes.
Okay. So just between using, not a medical term or scientific term, but the shoulder blade and Mr. Onfroy's neck and head?
Yes.
And what was the direction of fire? And if, well, first, before I ask you that, explain what direction of fire is.
Direction of fire we have determined according with the position of the body, front to back, right to left, and up to down.
Okay, so for those of us that may have never heard of some of these terms before, using anatomical position again, when you say right to left or left to right, what does that mean on a particular victim?
All times.
Starting with wound A.
Starting from this wound A, it's according to position of the body. So direction of this gunshot wound was from the left to right, of decedent's left to right, back to front.
Okay.
And downward.
Okay, so left, coming in from the left side of the victim. So the projectile went from the left side of the victim to the right.
Correct.
From front to back, and then downward. Is that what you said?
No, from back to front.
It's from back to front and then downward.
Yes.
Okay, now, I know that you weren't on scene when this homicide occurred, but does that give you some information and determination of where the muzzle, and I know you can't say shooter because you don't know, but where the muzzle was when the firearm shot the victim for wound A?
Yes, muzzle has to be above the decedent and behind him.
Above and behind?
Yes.
Okay, so if, for example, the decedent is sitting in a BMW i8, which is a sports car, in the driver's seat, okay? Would that wound, A, be consistent with a shooter holding a firearm and the shooter is over 6 foot while the victim is seated and the shooter is from the driver's side? Would that be consistent with that wound?
Yes, it's consistent.
Okay. You were able to recover a fired projectile from wound A?
Yes.
Okay, I'm going to show you what has been entered into evidence as 8 of 9 and 9 of 9 as part of states 70. Okay, now as part of, and actually I'm gonna ask Ms. Buckley to help me to find the previous entered exhibit regarding, from the medical examiner's office. I believe this was 67 or 63 or something like that. Okay, so as I show, it's always gonna be the easiest option. Okay, I'm showing you also, Doctor, what's been entered into evidence as states 67. And while, can you take a look at that while I show the jury 8 of 9 and 9 of 9?
Yes, it's projectile, but it's from second gunshot wound.
Okay, so that was labeled as projectile
Yes,
1.
because we found it first.
Ah, okay. So now then I'm gonna show you 7 of 9 and 6 of 9 of state 70. And I believe it's of projectile 2.
Yes. it's projectile 2.
Okay. And I'll go ahead and give that to the jury as well. Now, speaking of projectile 2, was projectile 2 what you recovered from Jahseh Onfroy in the autopsy from wound A?
Yes.
And as they're looking at that, with respect to projectile 1, because you said it was recovered first, was projectile 1, which the jury's also looking at, recovered from Jahseh Onfroy at autopsy from wound B?
Yes.
Wound B, what was the measurements of wound B?
Wound B was measured also 1 centimeter in diameter and was located 24 centimeters below the top of the head and 7 centimeters left of posterior midline. So it was behind wound A.
Okay, so using myself again, do you mind with your pen showing us where wound B?
was here.
Okay, so almost on top of, using layman's terms, the shoulder blade of Mr. Onfroy?
Yes.
Okay. And how close together were wound A and B?
They were very close, 2-3 centimeters.
And what was the direction of fire for wound B?
It was from the back to front and downward.
So when you say back to front, back, coming up to the front of Mr. Onfroy and downward.
Correct.
Okay, and so asking again, like I asked about wound A, if Mr. Onfroy was seated in a 2-seater BMW i8 in the driver's position, and there is a shooter with a firearm that is at least 6'1", somewhere around there, would that be consistent with wound B?
Yes, it's consistent.
Let's talk about wound C. Where was wound C located in terms of Mr. Onfroy?
Wound C was on the left side of the neck.
Okay, so same anatomical position, and if you could show us with your pen.
It was here, left, just keep your.
Oh, sorry,
Here, on the neck.
on the neck.
Left
Okay.
side of the neck.
So where my finger is?
Yes. Correct.
Okay, and what was the measurements for wound C?
It was 17 centimeters below the top of the head, and it was 1 centimeter in diameter, and it was located on the lateral midline of the neck.
Okay, in layman's terms, essentially right near Mr. Onfroy's head, but in his neck is where he was shot.
Correct.
Now, asking you about wound C again, or I should say, asking you a similar question for wound C. If the victim is seated in the driver's seat in an I-8 BMW and the shooter is on the driver's side, the shooter is at least 6'1", standing up, would that be consistent with wound C?
Yes.
As part of the examination, do you also collect samples of DNA from Mr. Onfroy?
Yes.
And as part of those samples, do you collect them for preservation and for them to be later transmitted or transferred to the Broward Sheriff's Office in case it's needed for analysis?
Yes.
Did you do that in this case?
Yes.
How about fingerprints? I'm going to show you what's already been entered into evidence as states 68. And you recognize state 68?
Yes.
How do you recognize state 68?
Because it has identification number and name of deceased.
Okay, same identification number that you indicated earlier is unique and identifiable by the medical examiner 18-1808.
Yes.
And during the autopsy, I know this may sound like a silly question, but you actually rolled Mr. Onfroy's fingerprint in order to collect this his fingerprints on this card?
Yes, our technician did.
Okay, it was also preserved as part of the autopsy, correct? By this card?
Yes.
Were you able to determine, based on the 3 wounds that Mr. Onfroy had, how close the muzzle of the firearm was to the victim?
I didn't see no shoot, no stippling. It means that gunshot, muzzle has to be more than 1-2 feet from the body. If it's more close, you can see stippling on the body or shoot. If it's more far than 1-2 feet, you do not see this evidence. So my assumption is it's not contact gunshot wound.
Okay, so I'm going to show you, I'm showing the jury 3 of 9 of state 70, which is a close-up of the wounds, A, B, and C.
Yes.
Okay, so as the jury's looking at, can you explain what is stippling?
Stippling is tattooing practically. When gunpowder burning, it makes tattooing on the body, some abrasions, and we call it stippling.
Okay, so earlier we heard from a firearms analyst that described how when a projectile is expelled from a muzzle, it creates like a mini explosion.
Right.
And so what you're indicating is stippling is if the muzzle is how close to the victim's skin?
1 feet.
1 foot? Less than
1 feet.
Less than 1 foot, then it'll create almost like a tattooing effect on the wound.
Correct.
And what does it mean if you see the absence of that on wounds A, B, and C?
If I see,
If you don't see any of that small tattooing?
that means that shot was more than 1 foot from the body.
More than 1 foot. Okay, and so you've never seen the surveillance in this case, correct?
No.
All right, but we have it entered into evidence, and so if we're able to see the homicide and it shows that where the position of the shooter is, it would be consistent. Would you agree with what you're saying, that it's that the muzzle was more than 1 to 2 feet?
Yes.
Now, you ultimately made a determination as to cause of death of Mr. Onfroy in this case, correct?
Yes.
And what was your determination as to the cause of death of Mr. Onfroy?
Cause of death is multiple gunshot wounds.
And that's from the wounds that you discussed today?
Correct.
And what was the manner of death as to Mr. Onfroy?
Manner of death is homicide.
No further questions.
Cross-examine.
Dr. Boyko, you took swabs of the decedent's fingernails, correct?
Yes.
Can you tell the jury how you did that?
Yes, we take swabs and to make this, we take swab from each fingernail, and we also take clipping on these nails.
Okay, so a swab is sort of
Swab is special swab which we take under the fingernails and make this dry and put for storage.
and you also actually cut the fingernails off or clip fingernail clippings off from the decedent, correct?
Correct.
All right. And you provide those to law enforcement, correct?
Yes.
All right. Is that something that's done in every case, or is it specific to this case?
Well, it's done for homicides usually. Usually police require it, so we collect it.
And then you indicate, I want to make sure that we understand 3 gunshot wounds, correct?
Yes.
And those 3 gunshot wounds were caused by 3 separate bullets, correct?
Yes.
Nothing further. Thank you, Judge.
Question on behalf of Mr. Newton?
No questions.
Thank you. On behalf
No
of Mr.
questions,
Newton?
Judge. No questions.
Any read?
Very quickly, Judge, with respect to how Mr. Onfroy was transferred to the medical examiner's office, was he already cleaned up and washed up from the hospital?
No.
Okay, so in what condition did he come into the medical examiner's office?
Well, he died in hospital on operation table, and as he died there, our investigators put him in plastic body bag, sealed this body bag with plastic red seal, and transported to our office. So there was no interaction with the body.
From surgery?
Correct.
Okay.
After surgery.
After surgery. And so you've performed thousands of autopsies and you're also a medical doctor. In preparation for surgery, is a particular patient, and in this case, decedent, are they prepared for surgery by the wounds that are going to be have operation on sanitized?
Yes. Also speculation.
If you could answer.
Yes.
And what is the procedure to sanitize a patient prior to surgery?
The cleaning body is usually ethanol spilled.
With what?
Ethanol spilled.
Okay, and what does that do? Does it kill?
Or some disinfectant, yes.
Disinfectant?
Yes, it kills germs.
And it kills germs because the operating room has to be sanitized, correct?
Correct.
And also the instruments that are used for surgery have to be sanitized, correct?
Yes.
In addition to sanitizing the room and the patient, are you aware, does that also affect possibly the collection of DNA?
Yes.
No further questions.
Any cross based on read?
Yes. You were not present at the hospital for this individual's surgery, correct?
No.
You couldn't testify as to what was done at this hospital to try to save this man's life, correct?
No.
All right. And you couldn't testify as to how quickly the hospital staff tried to save his life, correct?
No.
Nothing further.
Nothing, Your Honor.
Thank you, doctor. You're excused. County Council. So you get to fight with,
I never met
Cohen and Ed Hogue back to back.
Awesome.
And they come back just a little bit.
Judge, as we're, just because I understand Your Honor's made a ruling, but Mr. Kimmock has made a point to point out that the next of kin was emotional. She's still emotional outside the presence of the jury. So there was no intentional act by the state or the next of kin to try
I
to
don't think anyone's
assuage it.
suggesting that that's somehow staged and not genuine.
Okay,
And again, it was discussed beforehand.
okay.
Ray Magliozzi here. eBay Motors has 122 million parts. Hey, Dave.
Yep. Wait,
How are those new wipers?
they're small.
For parts that fit your vehicle, go to eBay Motors. Let's ride.